In this lecture, we'll be covering chapters 37, 38, and 39. Chapter 37, Principles of Insurance. Insurance is a contract whereby the insured transfers the risk of financial loss to the risk bearer for a fee. Some of the most important terms of insurance are insurer or underwriter, that is the company writing the insurance, insured or policyholder, the person covered, beneficiary, the one to whom the life insurance proceeds are to be paid, policy, that's the written contract, face, that's the maximum amount the insurer agrees to pay, premium, the consideration paid by the insured, risk, the danger of loss or injury, hazards are factors such as fire, flood, and sleet that contribute to the uncertainty. A rider is an addition to an insurance policy to modify, extend, or limit the base contract. And a binder is a temporary contract of insurance before the formal policy is issued. There are two types of insurance companies: stock companies, those formed as a regular corporation by the sale of stock, and mutual companies, those that are owned by the policyholders. To become an insured, one must have an insurable interest. To take out a policy of insurance, a person must be competent to contract. 5 principles that have special significance for insurance contracts are as follows. Willful concealment of material facts renders the contract voidable. Representations relative to material facts concerning the insurance contract must be true. Warranties, except in those states that have modified the common law, must be absolutely true whether they're relevant or not. Subrogation is the right of the insurance company to obtain all the rights of the insured after the claim is paid. And estoppel arises when one, by statements or by acts, leads another to believe a conclusion that is not true. Let's review the chapter review questions for chapter 37. What risks does an insurance company assume when a loss occurs, and what risk does it not assume? When a loss occurs, the insurance company assumes the risk caused by normal hazards, including negligence by the insured. An insurance company does not assume the risk caused by gross negligence. Question 2. Is the insured responsible for all increased risk when a loss occurs? When a loss occurs, the insured must use all due diligence to minimize it. However, the insured has no responsibility for an increased risk over which the insured has no control or knowledge. Question 3. What are the differences between a stock insurance company and a mutual insurance company? A stock insurance company is a corporation for which the original investment was made by stockholders who elect the board of directors, which conducts its business. The stockholders receive any profits as dividends. In a mutual insurance company, the policyholder is the member and owner and correspond to the stockholders in a stock company. The policyholders are both the insurer and the insured and share profits in the ratio their policy has to the total amount of insurance in force. Question 4. Why must a person have an insurable interest in order to be a policyholder? A person must have an insurable interest in order to be a policyholder because if the insured had no interest to protect, there would be no assumption of the risk and hence no insurance. Question 5A, when must a person have an insurable interest for life insurance purposes? A person must have an insurable interest in the life of the insured at the time the policy is taken out for life insurance. 5B, 3 examples of relationships giving rise to an insurable interest for life insurance. Relationships giving rise to an insurable interest for life insurance include parents and children, husband and wife, partner and co-partner, and a creditor on the life of the debtor to the extent of the debt. Question 6, does the rule rendering an insurance contract voidable as a result of concealment apply with equal force to all types of property insurance? The rule of concealment does not apply with equal force to all types of property insurance, since where an agent has an opportunity to inspect the property, the insurance company waives the right to void the contract. Question 7, under what circumstances will a misstatement of material fact by an insured prior to the finalization of an insurance contract not invalidate the contract? If the insurance application only requires the applicant to answer questions to the best of the applicant's knowledge and belief, and the applicant has answered truthfully, the fact that the applicant is unaware of the truth will not invalidate the contract. Question 8, how does a warranty differ from a representation? A warranty is included in the actual contract of insurance or incorporated by reference, while representations are independent and in a separate writing. Also, a false representation must concern a material fact in order to void a policy, while a warranty may concern any fact or be any promise and must be absolutely true or strictly performed. Question 9, when does the principle of subrogation apply? The principle of subrogation applies if the insurer pays a claim to the insured, because then the insurer has a right to any claims that the insured had because of the loss. Question 10, when can estoppel arise? An estoppel can arise whenever a party, by statements or actions, leads a second party to a conclusion, even if false, on which the second party relies. If the second party would be harmed if the first party were later allowed to show that the conclusion was not true, there is an estoppel. Chapter 38, Types of Insurance. Life insurance is a contract by which the insurer pays a specified sum or sums of money to a beneficiary upon the death of the insured. The most important types of life insurance are term life insurance, which provides protection for a stipulated number of years. The policy may provide for a level amount of protection during the life of the policy or for a periodic, usually monthly, decrease in the face of the policy as the need decreases. Endowment insurance. With endowment insurance, premiums are paid for a limited period, and if the insured is still living at the end of that period, the face amount is paid to the insured. And whole life insurance. This is where the insured agrees to pay the premium until the age of 100 or death. Life insurance companies may limit the risk they assume. The most common restrictions are suicide and death from war activity. Premiums must be paid within the time specified by the policy, or the policy may lapse. Life insurance companies are required by law to provide a grace period of 30 or 31 days for for payment of late premiums in every life insurance policy. Life insurance policies are made incontestable either by statute or by the policies themselves after a certain period of time, usually 1 or 2 years. The insured has the right to change the beneficiary of a policy. Any claims under an insurance policy may be assigned. An annuity insurance contract pays the insured a fixed period payment for life. Property insurance is a contract whereby the insurer, in return for a premium, agrees to reimburse the insured for loss or damage to specified property that is caused by the hazards covered. Fire insurance covers damage to property caused by what are known as hostile fires. The type of fire insurance policy indicates the nature of the risk assumed. Fire insurance policies may be open, valued, specific, blanket, or floating. Both personal and real property must be described with reasonable accuracy. Under the principles of coinsurance, the insured assumes a portion of the risk. Most insurance contracts give the insurer the option of paying the amount of the loss or repairing or replacing the property. A defense clause requires the insurer to defend the insured against damage claims, but the insured must give the fullest cooperation to the insured. The major classes of automobile insurance are physical damage insurance and public liability insurance. Physical damage insurance covers the risk of injury or damages to the car itself. Fire insurance, much of the law of fire insurance discussed previously applies to automobile insurance. Theft insurance usually covers theft, conversion, robbery, pilferage of parts, and damage to the car as a result of theft or attempted theft. It does not include theft of packages, wearing apparel, and similar items left in the car. Collision insurance covers all damage to the car caused by a collision or upset. Most collision insurance policies have a deductible clause. Comprehensive coverage includes loss due to windstorm, earthquake, flood, strike, spray from trees, malicious mischief, submersion in water, acid from a battery, riot, glass breakage, hail, and falling aircraft. Public liability insurance covers loss for damage to the property and the life of other people. Bodily injury insurance covers the risk of bodily injury to the insured's passengers, pedestrians, or other occupants of another car. Property damage insurance covers any loss to another person's property for which the insured is held liable, up to the face value of the policy. The last clear chance rule modifies the contributory negligence rule by providing that the driver who had one last clear chance to avoid hitting the other driver and failed to take it is liable even though the other driver was negligent. Normally, the one who brought suit must have been in no way negligent. People with poor driving records can be insured under the assigned risk rule. Let's go over our review questions for Chapter 38. Question 1. What is the difference between level term and decreasing term life insurance? In level term contracts, the face amount remains the same during the entire term of the policy. In decreasing term insurance, the length of time the proceeds are collected or the face amount decreases over the life of the policy. Question 2. What is a double indemnity rider? A rider requiring the insured to make a greater payment, customarily twice the ordinary amount, when death is caused by accidental means, is called a double indemnity rider. Question 3. Why is it desirable for the insured to have a grace period in a life insurance policy? It's desirable for the insured to have a grace period in a life insurance policy so that the policy does not lapse or get forfeited because of paying the premium one day late. To be reinstated or get a new policy, the insured might have to pass a new physical examination and pay a higher premium. Question 4. May a beneficiary assign a life insurance policy? A beneficiary may assign a life insurance policy. However, the insured might change beneficiaries. If the assignment is made after the insured has died, the assignment is an ordinary assignment of an existing money claim. Question 5. What risk does a fire insurance policy normally cover? A fire insurance policy normally covers the risk of damage to property caused only by an actual hostile fire. Question 6. Why must property and its location be described accurately? Property and its location must be described accurately in order to identify the property and to inform the insurer of the nature of the risk involved. Question 7. What does an 80% coinsurance clause in an insurance policy mean? An 80% coinsurance clause is an insurance policy means that the company will not pay the full amount of a partial loss unless insurance is carried for at least 80% of the value of the property. Question 8. What kinds of losses does an auto theft policy cover? An auto theft policy covers the wrongful deprivation of the car without claim of right, as well as pilferage of any parts of the car and damage to the car by theft or attempted theft. Question 9. What does automobile bodily injury insurance cover? Automobile bodily injury insurance covers the risk of bodily injury to the insured's passengers, pedestrians, or other occupants of another car. Question 10. What is a no-fault insurance plan? Under a no-fault insurance plan, insurance companies pay for injuries suffered by their insureds, no matter who has responsibility for negligence. Chapter 39, Security Devices. A contract of guarantee or suretyship is an agreement whereby one party promises to be responsible for the debt, default, or obligation of another. In recent years, bonding companies have taken over most of the business of guaranteeing an employer against losses due to the dishonesty of an employee. The bonding company's obligation arises from its written contract with the employer. There are always three parties to a contract of guarantee or of suretyship: the guarantor or surety, the creditor, and the principal. A surety is one who assumes a primary obligation, but with the principal receiving the benefit. A guarantor is one who assumes only a secondary obligation. The obligation is contingent upon the failure of the principal to pay. There are three reasons why it is necessary to distinguish between a contract of guarantee and a contract of suretyship. One is form. The contract of guarantee must be in writing. Secondly is default. A surety is not entitled to notice of default while a guarantor is entitled to notice. And 3, remedy. In a contract of guarantee, the creditor must exhaust all remedies against the principal before proceeding against the guarantor. The rights of the guarantor and the surety are as follows. 1, indemnity. A guarantor or surety who pays the debt or obligation of the principal is entitled to be reimbursed by the principal for the amount paid. 2nd is subrogation. The guarantor or the surety who pays the debt of the principal is entitled to all property, liens, or securities that were held by the creditor to secure the payment of the debt. 3, contribution. One of 2 or more guarantors or sureties who have paid more than a proportionate share of the debt are entitled to recover from the other guarantors or sureties the amount in excess of the pro rata share of the loss. And 4, exoneration. A surety for the benefit of another has a right to insist the debt be paid when due. The guarantor or the surety may be discharged by 1, an extension of time by the creditor without the consent of the surety or guarantor and for consideration. 2, a material alteration of the contract by the creditor. And 3, a loss or return of any collateral held by the creditor. A secured credit sale occurs when the seller retains the right to repossess the item sold if the buyer breaches the sales contract. A security agreement is a written agreement between the seller, also known as the creditor, and the buyer, also known as the debtor, that the creditor has a security interest in the collateral. The security agreement describes the collateral and is signed by the buyer. The rights of the seller under a security agreement may be transferred. The buyer has the right to transfer the collateral and to require a determination of the amount owed. When the rights of the seller to the collateral are superior to those of any third person, the seller is said to have a perfected security interest. Filing perfects a security interest in inventory, equipment, and fixtures. A security interest in consumer goods does not need to be filed in order to be perfected. A filed financing statement is effective for 5 years from its date. Filing continuation statements can extend the effectiveness of the file. Upon default, the seller has a right to repossession and resale. The buyer has the right to redemption and an accounting. Let's go over our Chapter 39 summary questions. Question 1, what is the difference between a guarantee and suretyship in those states that retain a distinction between them? In those states that retain a distinction between a guarantee and a suretyship, the surety has direct and primary responsibility for the debt or obligation, just like the principal debtor, while a guarantor's comes into effect only in the event the principal defaults. Question 2, what requirements are there with respect to form for contracts of guarantee and contracts of suretyship? All the essential elements of a contract must be present in both contracts of guarantee and contracts of suretyship. However, a contract of guarantee must be in writing, while contracts of suretyship may normally be oral. Question 3, what remedy does a guarantor damaged by the failure to receive notice of default of the principal have? A guarantor damaged by the failure to receive notice of default of the principal has the right to offset the amount of the damage against the claim of the creditor. Question 4. What right does a guarantor or surety who pays the debt or obligation of the principal have, and what is this right called? A guarantor or surety who pays the debt or obligation of the principal has the right to be reimbursed by the principal, and this right is known as the right of indemnity. Question 5. What is the impact on a surety when a creditor fails to compel payment when due? When a creditor fails to compel payment when due, a surety is released in cases where the debtor can pay. Question 6. Under what circumstances will the creditor's extension of the time of the debt discharge a surety or guarantor? The creditor's extension of time of the debt discharges a surety or guarantor when it is done without the consent of the surety or guarantor and for consideration. Question 7. How long must collateral be held for the benefit of a surety? For the benefit of a surety, collateral must be held until the debtor pays the debt in full. Question 8. How may a buyer or a debtor who wants to determine the amount owed get such a determination from the seller or the creditor? A buyer who wants to determine the amount owed may sign a statement indicating the amount of unpaid indebtedness believed to be owed as of a specified date and send it to the seller with the request that the statement be approved or corrected and then returned. Question 9. How is a security interest perfected in A. Inventory and equipment, B. Fixtures, and C. Consumer goods? A security interest is perfected in inventory and equipment by filing a financing statement in the appropriate public office unless the interest is noted on the document of title. Fixtures by filing a financing statement in the office where a mortgage on the real estate involved would be filed or recorded. And consumer goods as soon as it attaches and without filing in most cases. Question 10. When a seller repossesses collateral after a default, what may the seller do with it? When a seller repossesses collateral after a default, the seller may retain the collateral in satisfaction of the debt, unless the debtor, after being notified, objects, or the seller may sell the collateral as long as the disposition is commercially reasonable. Please email the answer to question 10 of chapter 39.